The New Zealand Parole Board is part of the criminal justice system. Completely independent and impartial, the board works to protect the public by assessing an offender's risk, to decide whether they can be safely released from prison to serve the remainder of their sentence in the community, and if so, what conditions they should have. The board also sets conditions once an offender reaches the end of their sentence. The board is made up of members from a wide range of backgrounds. While some members are legally qualified, others bring a wealth of knowledge and experience from careers as diverse as former senior police officers, health practitioners and social work professionals. Every year, the board has around 10,000 hearings, making decisions about long-term offenders. The board does not decide when an offender must be considered for parole. This is set out in the Parole Act. Most offenders sentenced to more than 2 years imprisonment become eligible for parole after serving a third of their sentence, unless the sentencing judge has set a longer minimum non-parole period. For offenders serving life sentences, an automatic non-parole period of 10 years is imposed, again unless the sentencing judge sets a longer minimum non-parole period. When deciding whether an offender should be released from prison, the board carefully considers a range of information: submissions from victims and reports prepared by professionals, details of previous offending, reports and psychological assessments are put together to paint a detailed picture of each offender's past, present and future plans. Decisions are made by panels of at least 3 members. Each panel is chaired by a judge or senior lawyer. They're not legally allowed to decide whether an offender has been punished enough. Their task is only to decide on the degree of risk that each offender poses, not just in terms of community safety, but also in the interest of victims. In assessing undue risk, the board must consider both the likelihood of further offending and the nature and seriousness of any likely subsequent offending, ensuring that each offender referred to the board is given rigorous and fair consideration. Having decided that the offender no longer poses an undue risk, the board must release them on parole. Where the board decides that early release is not appropriate, offenders receive detailed information on what factors influence that decision. There are cases where the board's only role is to impose release conditions. When an offender has reached their statutory release date, they are required by law to be released. The board's only role in these cases is to set the conditions that must be complied with when released.